Believe it or not, there are things that debt collectors absolutely do not want you to understand. They thrive on confusion, fear, and intimidation. And if you knew the truth, a lot of their power would vanish overnight. Welcome back to Success with Steven. My name is Steven Smith. On this channel, we discuss all things financial literacy. In this video, I'm going to reveal those secrets, explain what's really happening behind the scenes when a collection agency is attempting to contact you, and I'm going to show you how you may be able to avoid paying them altogether using consumer law. But even more importantly, we're going to talk about your rights, the rights that they hope you'll never discover, because the less you know, the more money they can make. So without further ado, let's get right into the video. Nothing makes your stomach drop like opening your mailbox or seeing a big bold letter from a collection agency. The words are intimidating and the language is designed to scare you, and the threats always hang over your head. Pay now or face legal action. On top of that, they might call you nonstop, sometimes multiple times a day. They may even go as far as calling your workplace or sending emails or leaving messages with your friends and your family. That feeling of dread, that's not by accident. It's their primary tool because here's the truth. One of their most powerful weapons is fear. And if they can make you panic, they can usually get you to pay, even if they don't actually have the legal authority or documentation to enforce the debt in court. Now, before we go any further, this is not legal advice. I am not advising you on what to do. I am providing you with information for entertainment purposes only. I will also leave links in the description for all the information that we discussed today, so you can look this stuff up yourself and make sure that you fully understand it. Under no circumstances will I ever do this for you or help you in any way, form, or fashion. So if you contact me by email, it's going to be ignored. I just want to make sure that I disclose that for legal reasons to protect me and to protect you. Now, once you understand how this really works, you'll see that their threats don't carry as much weight as they want you to believe. Now, let's use a very simple example. Imagine you have a credit card with a $5,000 balance. Life throws you a curveball. Maybe you lose your job. Maybe you get hit with an unexpected medical bill. Maybe you simply can't keep up and you fall behind. You know, this is life. Things just happen. You miss payment after payment until the account eventually goes into default. The bank will send you the statement. They'll tack on fees, maybe bump the balance up to $6,500 after months of penalties and interest. But after roughly 180 days of non-payment, banks are required by law to charge off the account, meaning they write it off as a loss in their books, but this doesn't erase your obligation. The debt is still legally collectible. And sometimes they'll receive a corresponding tax credit, and they may send you a document called a 1099-C tax form. We've talked about this in previous videos, and I want to be clear on this part. A bank does not always send a 1099-C for a charge-off, but they are required to do so if certain conditions are met. And yes, a bank can sell a debt to a collection agency without issuing you a Form 1099-C. But let's go a little deeper. The bank is not required to issue this form when selling a debt because the debt itself has not been canceled, forgiven, or discharged. Instead, it has simply been transferred to a different owner. Now, a bank must send a 1099-C for an identifiable event, and it has to be an event of $600 or more. This event signifies that the bank is no longer pursuing the debt, and that will include situations like a debt settlement with the bank for less than the full amount, the expiration of the statute of limitations for collecting the debt, as well as a decision by the creditor to stop collection activity. Now, we are going to get into that a little bit further. Just remember everything that I said there. And again, I previously stated this in charge-off videos, in a video about 1099-Cs. We went through and actually read the entire tax form. If you haven't seen that, then I suggest you refer back to that video. I'm going to link it right here. Really quick, I want to talk about how banks also protect themselves structurally. They maintain a reserve for bad debt. In some cases, they use insurance or a securitization. They'll bundle debt and sell them to investors. This spreads out their risk so that one person's default does not sink the entire system. I talked about these securities in a previous video about Capital One and how they actually use a tier bucketing system. Again, all these things are sort of related, but there's a lot of money to be made on subprime lending. And there are so many ways that a lot of financial institutions and investors make money off of it. Now, here's where it gets interesting. The bank decides to make back a tiny portion of your debt by selling to a collection agency. And here's the shocking part. They don't sell for anything close to what you owe. Many times, debts are sold for pennies on the dollar, literally between like 6 cents to 20 cents for every dollar. So if your 6,500 account lands into the hands of a collection agency, they might only pay $390 for it on the low end. So think about that. They didn't lend you money. They didn't provide you with a service. They bought a piece of paper that says you once owed someone else money, and now they're trying to squeeze you for the full amount. And that's their business model. They gamble on fear, hoping enough people will pay to make their investment worth it. Now, I'm going to speak objectively here because debt collection agencies are still just doing a job, and it's a job that pays them, for their business. But let's talk about what you actually can do to protect yourself. Now, there is the Fair Debt Collection Practices Act, which is a federal law. And in that law, it explicitly states what debt collectors can and cannot do. Federal law makes it illegal for debt collectors to use unfair, abusive practices or deceptive statements to collect the debt. Next, I'll explain the steps you can take to protect yourself and the secret that debt collectors don't want you to know. The FDCPA is found in Section 1692 through 1692P of Title 15 of the United States Code. There's a link in the description of the video if you'd like to read this. I highly recommend that you do. You should know your rights, not just listen to what I'm saying. While the FDCPA sets strict rules about how debt collectors can act, it does not prevent them from suing you if you actually owe the debt and the debt is still within the statute of limitations. Now, this is an important distinction because people often assume that once they waive the FDCPA in a collector's face, the debt goes away. This is not the case. What the FDCPA does is regulate behavior, not erase obligation. However, under this law, debt collectors are required to treat you fairly, and with that presents an opportunity for you to fight back. So number one, they cannot harass you. They cannot make threats. They cannot abuse you over the phone, and they cannot make false claims about the debt. Number two, if they tell you that the police are going to show up at your door tomorrow morning unless you pay this, that is a violation of federal law. If they scream at you, if they use profanity, if they call you repeatedly just to irritate you, that is also a violation. And number three, and this next part is important, collectors are also required to provide you with written notice of the debt within 5 days of first contacting you. This notice has to spell out the amount you allegedly owe, the name of the creditor, and information about your rights to dispute the debt. If you do not receive this notice, the collector is already breaking the law. And this leads us to perhaps one of the most powerful protections under FDCPA, and that is your right to demand validation of the debt. This is one of the things that they don't want you to know. If you request this in writing within 30 days of first being contacted, the collector must pause all collection efforts until they provide verification. You know what that means? It means no more calls, it means no more letters, and no further collection attempts until they show you proof that you actually owe what they claim. And this is where you can prevail against them. You see, debt collectors don't always have complete documentation up front. This proof is not always easy for them to come up with. Many debts are sold over and over again from one collection agency to another, and eventually the paperwork often gets lost along the way. Most of the time they buy these debts in bulk and they really don't have the information to keep up with. Now, if they can't validate the debt, they cannot legally continue to pursue you, and they certainly cannot sue you for it. Another key rule under the FDCPA is that debt collectors cannot misrepresent legal action. For example, they cannot threaten to sue you unless they genuinely plan to take you to court. They cannot tell you that you will be arrested for non-payment because debt is a civil matter, not a criminal one. They cannot imply that they have powers they don't actually have. And finally, the FDCPA restricts when and how they can contact you. They cannot call before 8 in the morning or after 9 at night. They cannot call you at work if you tell them your employer does not allow it. And if you tell them in writing to stop contacting you altogether, they must comply, with the limited exception of confirming that they will stop contacting you or notifying you of specific legal action. Now, I want to be clear once again, even with all these protections, it is important to remember that the FDCPA does not stop the collector or a creditor from suing you if the debt is real, valid, and within the statute of limitations. In other words, just because they have to follow the rules does not mean that the debt disappears. This is why it's so important to know your options when it comes to reducing or preventing the risk of a lawsuit, which now brings me to the other part of this, your statute of limitations and the options that you have to defend yourself. Now, I've talked about this in a previous video, but I just want to make sure that we understand, because this is going to be one of the most powerful secrets that you have in your arsenal, and I rarely ever hear anyone talk about it. The statute of limitations on debt is a state law that sets a deadline for how long a lender or collection agency has to sue you for non-payment. Think of it as a timer that starts when the debt goes into default. Once that timer runs out, the debt becomes time barred, which means the collector is no longer allowed to file a valid lawsuit to force you to pay. Now, this does not erase the debt. It does not make the balance disappear. It simply limits one specific remedy, taking you to court to get a judgment. Collectors can still ask you to pay, but oddly enough, if you actually look at a letter from a debt collector and your debt is time barred, it'll actually state at the bottom that you paying is voluntary, meaning that you're giving them money because you want to, not because legally you have to. But once again, they can still contact you within the bounds of the law, but if the statute has expired, they are not supposed to threaten lawsuits or actually file one. And if they do, you have the most powerful defense to raise, provided you respond properly and on time. I've been telling people this for a long time. If they ever see that they're being sued, one of the first things that you should do is check the statute of limitations. And you want to respond and you want to show up to court, because if you do, the only thing you have to say is the debt is time barred. I do not have to pay this legally. And then the judge will dismiss the case. If you don't show up, which some collectors bank on, then you will get a default judgment and they can garnish your wages, all because you didn't show up in the first place. Now, there are 4 different types of debts, and each type can have a different timeline. The first one is open-ended debt. That's like credit cards and lines of credit. They usually have shorter limits. Written contracts and promissory notes often carry longer ones. Oral contracts are harder to prove and often expire very quickly. And every state will handle these slightly differently. So just to recap, number 1 is open-ended debt. Number 2 is written contracts, and of course the promissory notes. And then the 4th one is oral contracts. So those are your 4 different types of debt. The clock for these debts typically begin when you breach the agreement, which usually means the date of default. So for credit cards, this is often the date you first missed a payment that you never caught up on. Some states count from the last payment date. Others look to when the account first went seriously delinquent and it was not cured. Because that detail matters, it's smart to check your state's rule and review your statements to identify when the default actually occurred. So for example, I live in the state of Nevada. Open-ended accounts such as credit cards expire in 4 years. So let's say I had a late payment for a credit card in January of 2020. This card defaulted and was charged off 180 days later. Eventually, the debt was sold to a collection agency. Now, under my state statute of limitations for debt collection, an agency or the original creditor would have until January of 2024 to pursue legal action. If they didn't, then legally, I can't be taken to court. The other available option to you is after 4 years, you could request that the original creditor grant you a 1099-C. Now, they don't have to, but they can. Now that debt has passed the statute of limitations. At that point, collectors can no longer contact you about the debt. You can actually send them this, or you can show this in court, but now they can do nothing at all. And you can also use this same tax form to have the debt deleted from your credit report. If you want more information about that, please refer to my 1099-C video. I'm going to link that here as well. Now, for clarification, it doesn't mean they can't contact me about the debt, but they can't sue me either. And I still have the option to send a cease and desist letter. So I hope this example makes a lot of sense. Now, there is a link in the description for the statute of limitations for every state. I highly recommend that you check yours. So currently we are on incharge.org. This website has the statute of limitations on debt collection by state, and it was recently updated April 24th of 2025. Again, I highly recommend that you read this. You want to also just make note of some of the details here, like the time frame is set by each state and varies from just 3 years in 13 states to 10 years in 2 states, with the other 25 states somewhere in between. And if we continue to scroll down here, I'm not going to stay on this very long, guys, because again, link is in the description. But if we scroll down here, you can look at the different types of debt: written contracts, oral contracts, the promissory notes, and then open-ended accounts, including credit cards. Now, for a lot of people, usually the charge-offs that they have are going to be credit cards or lines of credit. I rarely ever see oral contracts or some of these other ones, but just for an example, if you lived in the state of Alabama after 3 years, and you'll have to check exactly when they start from, but let's say it was the date you first went delinquent, this account can no longer be collected legally. They cannot take you to court to get you to pay legally. So you want to just scroll through here, and again, all states are here. Some are longer than others, and it will depend on where you lived at when you actually open that account. That does make a difference. So, I mean, if you opened an account and you lived in DC when you opened it, but now you live in Florida, you'll still be held to the 3 years. Okay. So let's do a quick recap of the 2 powerful secrets that debt collectors do not want you to know. When it comes to shutting down a debt collection agency's pursuit of you, the 2 most powerful tools that you have at your disposal are the statute of limitations in your state and the debt validation letter. Most people don't realize how these 2 protections work together, but when used correctly, they can completely change the game in your favor. Don't forget as well that if your debt has passed the statute of limitations, then you can request a 1099-C, which can also aid you in getting that information removed from your credit report. And of course, it stops any debt collectors right in their tracks. And recapping the statute of limitations, every state in America has a legal time limit on how long creditors or collection agencies can file a lawsuit to collect on an unpaid debt. This time frame usually ranges between 3 and 6 years, but in some states, it can be even longer. Once that window of time has passed, the debt is considered time barred. This does not mean the debt magically disappears, but it does mean that a collector cannot legally take you to court, and you can also send a cease and desist letter so that they can no longer contact you unless they're going to have legal action, or to tell you that they'll no longer contact you, which means if they can't actually take legal action, the cease and desist letter will get them to stop contacting you altogether. And if they do continue to contact you, now you can take them to court and you can actually get money by suing them, but that's a totally separate matter. And again, I want to emphasize that if the debt is past the statute of limitations, it just means that the collector cannot legally take you to court and actually win. But I have seen where collection agencies will still attempt to take you to court, but they expect for you not to show up because you don't know any better. And then they get a default judgment. So just know that's one other little trick that they can use, but you want to be aware of that. And that's why you always want to check the statute of limitations. So if you know this and you can prove that the clock has already run out, you have an extremely strong defense. However, be careful. Again, even if that debt is time barred, collectors may still try to contact you. And if you make a payment or even acknowledge the debt in writing, you could reset the clock. That will give them fresh time to sue you. And this is why understanding the statute of limitations in your state is so important. It gives you the confidence to push back when a collector is trying to get money that they can no longer legally enforce. Let's go back to the debt validation letter. Under the Fair Debt Collection Practices Act, you have the right to request proof that you actually owe the debt and a collector is trying to make you pay. Now, if you send a debt validation letter within 30 days of their first contact, that collector must stop all collection activity until they provide proper documentation. That means no calls, no letters, no threats, until they can prove the debt is legitimate. And because again, so many debts change hands multiple times as they're sold from one collection agency to another, they don't always have that information. And with each transfer, paperwork can be lost, incomplete, and simply never passed along. If the collector cannot produce solid proof that you owe the debt, they cannot legally continue to pursue you. When you combine these two protections, the results are very, very powerful. And if the debt is already outside the statute of limitations, you can use this as a defense against any potential lawsuits and also requesting that 1099-C from the original creditor. And if you do request validation and the collector cannot produce it, they must stop trying to collect altogether. Between these two tools, you can often stop a debt collection agency dead in its tracks. The key is to act quickly, put everything in writing, and know your rights so you can't be bullied into paying something you either do not owe or no longer legally are required to pay. And as a thank you for watching today's video, I've drafted a free debt validation letter and a cease and desist letter, and you can download this completely free on www.successwithstevensmith.com. Now, with those letters, there will be some details on how to use them and what you need to send. All you have to do is fill in your information. Once again, the debt validation letter is when they contact you in the first 30 days, they need to validate that debt. If they cannot do that, the follow-up would be the cease and desist letter. At that point, they can only contact you if they're telling you that they'll no longer contact you or if they're taking legal action. And if your debt is past the statute of limitations of your state, they can't even do that. And let's say that they tried. Even if they did, you now know exactly what you can do when you go to court. All you have to do is just show up. Once again, I want to thank you guys so much for watching this video. If you got any value from this information, please like the video, drop a comment below, and share this with someone who might actually need this information. I made this because of a coaching that I had asking about this exact same thing, and I felt like I didn't thoroughly answer the question. So again, I really do hope that this helps a lot of people. Don't forget to sign up for My Success University if you guys haven't already. It's a Discord group where we talk about things just like this on an almost daily basis. I would love to see you in there. And again, thank you guys so much for watching this video. You have a wonderful day.